Hello, I'm Rachel, this is Sarah, and we are part of the Real Estate Dispute Resolution team at Muckle. We are experiencing quite a few enquiries coming in from landlords asking about the impact of coronavirus on their obligations to their tenants. So we thought we would have a quick cup of tea and a chat about what's going on and recap of the existing obligations that landlords have to comply with, the new obligations imposed by the Fitness for Human Habitation Act, and the impact that coronavirus is having on being able to go in and do those inspections and remedial works. So just so we're all on the same page, landlords should already be aware of their existing obligations, which are primarily found in Section 11 of the Landlord and Tenant Act 1985, and that's broadly speaking to keep in repair the structure and exterior of the property and to keep in repair the installations for the supply of gas, water, electric, sanitation, heating, hot water. And then there will be any additional obligations which can generally be found in the contract or the lease or the tenancy agreement, which go over and above the statutory minimum.
That's right, and from the 20th of March this year, we've also got additional obligations imposed by the Fitness for Human Habitation Act. So they come into force for all tenancies regardless of the start date as of the 20th of March this year. Landlords may know that from the 20th of March last year, it applied for new tenancies entered into after that date. So in order to consider whether or not a property is fit for human habitation, a landlord needs to have regard to the Housing Health and Safety Rating System and the 29 hazards that are identified in there. And so far as landlords are concerned, the most important things that are likely to come up as a result of Fitness for Human Habitation issues is related to damp and mould and the obligations to ensure that properties are properly heated and ventilated. Whereas previously, and when you were looking at disrepairing obligations in isolation, it may have been the case that a heating system wasn't in disrepair or the lack of ventilation didn't impose any obligations on the landlord, but that's likely to change now following the new legislation coming into force. What it doesn't do is impose an obligation on a landlord for the way that the tenant treats the property. So as previously, they won't be liable for the tenant's use of the property themselves if they have caused a problem. Ideally, what landlords need to do is undertake regular inspections so that they can keep an eye on their properties and make sure that they are fit for human habitation and that those obligations exist throughout the tenancy. So they do need to keep an eye on the state of the properties, but that is likely to be difficult given the current situation and coronavirus and social distancing guidelines. Did you have any thoughts, Rachel, on what landlords can and should do in connection with gaining access into properties?
Yeah, and I think that's going to be the biggest concern for landlords is actually they have these obligations, and the guidance that has come out and the Coronavirus Act makes clear that those repairing obligations continue to exist, but landlords actually might be reluctant to go into properties, tenants might be self-isolated, so there are a whole host of issues that landlords need to be thinking about. So those tenants that they have in there might be reporting defects to them and saying these things need fixing, they're urgent, can you come and do them? It might be that disrepair claims are still dropping onto the landlord's doormats, and in which case you have to comply with the disrepair pre-action protocol, which gives you 20 working days from receipt of the letter of claim or from the expert report to propose works. But how can you do the works if you don't know what needs doing because you've not been able to get in and inspect? You've also got to think about compliance with gas safety regulations, where you have to check the installations every 12 months to certify that they're safe, and you can't necessarily agree an extension of that deadline with your tenant due to the current situation, because that time frame is set down in statute. Obviously, you've got the ability to do the check of gas safety installations 10 months after the last check without it affecting the date, but that doesn't necessarily help you if your deadline's fast approaching. So I think landlords need to be taking a deep review of all of their properties to see what deadlines are coming up and what they need to be doing, and dealing with that head on to see what kind of arrangements can be made with their tenants to be able to comply with those obligations. But landlords also need to be aware that there's probably going to be a lack of resource as well. So it might be that you have in-house staff that are going to do your inspections and works, but because of the coronavirus, you've got more people on sick or people on furlough. It might be that you have expert surveyors that go and do your expert reports for disrepair matters, in which case they might be reluctant to go in and undertake inspections if there's a risk that they might contract coronavirus from the tenant. Or you might have tenants that are reluctant to let people into their property because they don't want to take the risk that they might catch anything either. So I think there's a whole host of things that landlords need to be thinking about in order that they can comply. I think the key has to be deal with the matter, because those repairing obligations still are ongoing and you still have to be complying with them. But that being said, the guidance makes clear that landlords and tenants will be expected to take a pragmatic and sensible approach to dealing with repairs and doing the outstanding works only, maybe.
Thanks, Rachel. Yes, I think it's important to remember that it may be perfectly feasible to access properties if contractors have suitable personal protective equipment, maintain social distancing guidelines, and it may be that tenants can go into another room or go upstairs if the inspection is downstairs, that kind of thing. And obviously the tenant will need to ensure that the area is cleaned properly after the contractor has visited. As with all of these things, it's important to have communication with the tenant and also to document any agreements made. So if an agreement is reached that non-urgent works can be postponed, then make a note of that so that you've got a record if it becomes an issue at a later date. Of course, access does need to be granted in the case of emergency situations. So if there is a danger to somebody's health and safety, or a danger to property, or to comply with statutory requirements, and in those circumstances, if access can't be obtained and if there is no good reason for that, then a landlord may need to look at other remedies. I don't think possession action would be a sensible route to go down at the moment because of extended notice periods, but certainly access injunctions can be considered in appropriate cases.
Definitely. So who knows how the courts are going to deal with this, but I think the court will take a dim view of any tenants or solicitors that take advantage of the fact that landlords aren't able to, or are a little bit reluctant to go in and do non-essential works at the moment, but it remains to be seen. So thanks a lot for watching. If you've seen this video and you have any queries, do get in touch with us. This is probably the most social interaction we're going to be dealing with for the time being, so let us know what your thoughts are, and hopefully everything will be back to normal pretty soon. Until then, get in touch. Thanks a lot.
Thanks, bye.